Starting. All attendees are in listen-only mode.
Hello, and welcome to today's webinar, Managing Intellectual Property for Nonprofits and Small Businesses. I'm Christine Kulumani, Managing Attorney with the DC Bar Pro Bono Center's Nonprofit and Small Business Legal Assistance Programs. Thank you to my colleague Lauren, who has done all of the behind-the-scenes work to make today's webinar possible. Also, a huge thank you to our wonderful presenter today, Stefan Gerhofer, an attorney at the law firm Wilson Sonsini here in DC. Before we get started, a couple of logistics for today's presentation. First, if you are listening to us live, this webinar will be recorded. So you can come back and re-reference it, and you can send it to other organizations that you think would find it helpful. In addition, you have immediate access to the presentation slides in your GoToWebinar control panel under Handout. Those will also be made available along with the recording afterwards. If you have questions as we go through the presentation, please send them to me through the questions box in that same GoToWebinar control panel. We will try to get to as many questions as we have time for. As a reminder, this is a training presentation, so please ask general questions and not things that are very specific to your organization asking for legal advice. We will provide you with resources where you can get one-on-one legal assistance for your IP questions. Okay, with that out of the way, on to today's topic, intellectual property. What is intellectual property? And why is it so valuable to your organization? Well, today we'll dive into the various types of intellectual property protections available, explore how intellectual property can be handled with employees and independent contractors that do work with your organization, and we'll touch on intellectual property that's developed with or shared between different organizations. And with that agenda in front of us, I'm going to turn it over to you, Stefan.
Thank you so much, Christine, for the kind introduction. My name is Stefan Gerhofer. I'm an associate at Wilson Sonsini in the technology transactions practice, and I'm based in DC. It's a pleasure to be speaking with all of you today about managing IP for nonprofits and small businesses. And before we get started, just a very short disclaimer. This presentation is provided for informational purposes only and not intended to create an attorney-client relationship or constitute an advertisement, solicitation, or professional advice as to any particular situation. And with that out of the way, let's jump right in and start with a roadmap for today's presentation. There are three topics that I'd like to talk about. And the first one is really intended to set the stage and introduce intellectual property rights and technology, and also differentiate between these two terms. And in this first part, we'll cover all the major types of intellectual property rights, including patents, copyrights, trademarks, and trade secrets. And we'll try to sort of compare and contrast what different types of protection these IP rights offer. And with that in mind, we'll then address the second topic, which deals with employees and consultants, and what to keep in mind when these employees or consultants create intellectual property on behalf of an organization. As we'll see, if it's created for the business, it's helpful to ensure that all intellectual property rights are assigned or transferred to that organization so that it may be used going forward. And then third, we'll touch on what happens when an organization partners with others to, for example, embark on a collaborative project, and what topics to think about before going into such a collaboration. We only have an hour today, of course, and there's a lot to cover. So this presentation is really intended to give an overview of the types of IP that are out there and highlight some of the most important issues, so that in the day-to-day, when issues like that come up, it's easy to spot them and then think about them ahead of time. So let's move on to the first topic then, and start with a comparison between intellectual property rights and technology on the one hand and technology on the other. We frequently use the umbrella term intellectual property, which really corresponds to both. But for some of the topics that we'll encounter today, it's quite helpful to distinguish between the rights on the one hand and the technology on the other. So if we maybe start by looking at patents, as we'll see in just another slide, patents are exclusive rights that permit the owner of the patent to exclude others from practicing the invention. And as such, they're really a legal right that is limited in scope and duration, but it's not tied to any specific embodiment of that invention. So for example, if you have a patent that covers a machine or a tool, sure, the machine will likely be an embodiment of that patent, but the patent itself the protection of that patent will go broader than just that machine. Similarly, trademarks are rights that protect your brand so that another party can't use your brand and confuse consumers as to where products or services originate. And again, it's not tied to a specific product or services, but it really helps identify the origin of a product or service. Technology, on the other hand, technology is a broad term, but in the context of this presentation, it's best to sort of understand it as knowledge or know-how, if you will, which can be both tangible or intangible. So a machine would certainly be an example of sort of a tangible thing that embodies know-how that your organization may have. Software is more of an intangible asset that, of course, also has a lot of know-how embedded in it. And at the intersection between both, we sort of have copyrights and trade secrets as examples that are both intellectual property rights. Copyrights protect protect original works of authorship, but they're more closely linked to a specific embodiment, if you will. Like if you write a novel, you'll certainly have a copyright interest in that novel, but it's also more closely linked to that specific novel, more so than a patent would be. And so as we go through the presentation, it's just helpful to think back to this slide, especially when we talk about the coverage of certain IP rights. Starting then with patents, there are two types of patents. We'll start with the more common type, which is a utility patent. On the left-hand side here, you see an example of a patent that covers a support structure for a hammock. So you can see there's a hammock here. It's a little hard to see between those support beams, and it also has a sunshade, just as an example. And so patents protect new and useful inventions or discoveries, and these terms are really quite broad. So invention or discovery can refer to processes, machines, articles of manufacture, or composition of matter. But again, it's important to keep in mind those are negative rights. So when you apply for a patent, and if that patent ultimately issues, the patent owner would then be able to exclude others from making, using, or selling that invention. To be awarded a patent, you have to go through an application process with the U.S. Patent and Trademark Office. So you would essentially prepare an application that describes in detail what you think your invention is. You typically providing both drawings, such as the one shown on this title page here, and a detailed description of what the invention is, so that someone who is skilled in the practice, and the legal term is someone of an ordinary person skilled in the art, would be able to use your description to understand what it is that you're claiming. There are a number of requirements for a patent to grant on an application, and I've highlighted the three key ones here, which is the invention must be novel, it must be useful, and it must be non-obvious. And the usefulness requirement is generally, not sure what happened here, but let's go back. is generally a low bar, but novelty and non-obvious are really key. The idea of a patent is to essentially have a bargain with the public that consists of public disclosure of a new invention in return for a time-limited exclusive right that for a utility patent lasts 20 years from the time that the application is filed. And so when the USPTO receives an application, a patent examiner at the office will look at the application, will consult various types of sources to confirm or to assess if the application presents a novel invention, and typically there's a back and forth between the examiner and the applicant to determine what, if anything, is actually new in the invention so that the rights can be tailored appropriately. And the rights are actually set forth at the end of a patent. So when you look at the description that describes it, at the very end, you have a section that is called the claims. And for the example patent shown on the previous slide, this claim is shown for illustration here. Those claims, it's essentially one sentence that describes the elements of the exclusive right by referring to terms used in the description. So, for example, here you can see that the claim would relate to an interconnected hammock support that includes sunshade means, which refers to the support for the sunshade, and various other elements. And that really sets forth the exclusive right that if the patent grants is sort of the scope of the patent. And typically during examination that those claims are revised so that if the examiner raises an objection or rejection of the initial patent claims, those can be narrowed typically to be confined later on to just what is actually novel. Once a patent grants, it can be enforced. This exclusive right can be enforced against others, and such an enforcement would typically take place in federal court. Of course, an accused infringer that stands accused of infringing a patent may raise several types of defenses, including claiming that the product or service that the accused infringer makes is actually not within the scope of the patent. That would be called non-infringement. But the defendant may also raise claims as to the validity of the patent. And even though patents go through an examination process and are presumed valid in litigation, defendants can, of course, challenge the patent's validity, essentially, claiming that the patent should never have issued in litigation. And it's typical that such a validity challenge is raised. In addition to federal court, because U.S. patents only apply within the United States, if someone were to manufacture, say, a product abroad and try to import it into the United States, then there's also a separate proceeding by the International Trade Commission that could block importation. The process is similar to litigation in district court, but there are certainly many differences as well. But that's another option that is available with respect to patent enforcement. And it's also possible to take a patent back to the patent office outside of the court system, if you will, by someone concerned about the scope of the patent, taking it back to the patent office for them to have another look, and that is called a post-grant proceeding. Just to clarify a few misconceptions about patents. As I said, it's a negative right to exclude others, and so it does not necessarily permit the patent owner to actually use the technology or product principally for two reasons. The first one is that someone else might own another patent that overlaps with the technology, and while by filing a patent, it's a helpful public record to sort of show that what is claimed in the patent was known at that time, and sort of certainly would be a prior art to someone who filed a patent later on. Many of today's products, include numerous different types of inventions. So someone could have an invention that covers something outside of the scope of the patent, and therefore, even though your patent covers the product in one aspect, another patent could read on it as well. So that is certainly a possibility. It's also possible that patent claims, overlap with respect to related technology. But the second reason is outside of patent law, some products are regulated by the government for completely different reasons. So if you, for example, had a patent to a drug, then the FDA would certainly have something to say about whether that drug could actually be sold to the public, and obviously there would be an FDA approval process. So again, patents are rights to exclude; they don't permit, affirmatively to make something. And so just to illustrate the scope of the patent a little bit more, if you looked on the right hand side, where there's this overlap of circles, so if say a patent A had a scope of a piece of furniture comprising a surface and 4 legs, that could potentially, just for illustration, read both on a table and a chair. If someone else had a patent that claimed a chair comprising a seat, an armrest, and a backrest, there could be some overlap, right? That chair that has 4 legs and an armrest and a backrest might be in this overlap area here, whereas an office chair that has swivel legs would presumably not be covered by the first one. So it's important to always think about the scope of a patent and remind oneself that it's a right to exclude. And the last point on utility patents are territorial rights. So a U.S. patent would only cover the United States. If there's a product that is marketed internationally, then it can be helpful to seek patent protection elsewhere as well in key markets. And patent laws are somewhat reasonably uniform because of international treaties. But it's of course important to realize that there are some differences between the legal systems here and abroad, if that were to become relevant. Okay, switching gears a little bit, utility patents, we've seen, protect processes, functional features. There's also a design patent, which is solely focused on ornamental characteristics of an article. And in the example here is a football that essentially has like a little tail fin at the end. Which was a patent that was litigated a few decades ago, and for illustration, this tail fin for the football that presumably would help it fly better has some functional aspects to it, as you can see, because again, it would help the football fly better. But the design patent here would just cover the ornamental features of what the tail fin looks like, of what the football looks like. So it's, again, just focused on ornamental characteristics and not function. That said, there's nothing that prevents an applicant from filing both a design patent and a utility patent to try to cover both. The examination process for design patents is similar to utility patents, but if granted, a design patent lasts for 15 years from the date of issuance, whereas a utility patent lasts for 20 years from the date of filing. So a different duration of protection there. There's also some overlap between design patents and trade dress, as we'll see when we get to trademarks. Design patents, for a design patent to issue, the ornamental design must be new and non-obvious, and sort of the hallmark of patent protection. For trade dress, trade dress tries to focus on identifying the source of a product or service and avoid consumer confusion. So from the trade dress perspective, novelty is not important, and there can be some overlapping coverage here, as we'll see a bit later. With that in mind, the next IP right that I'd like to talk about is copyrights. And copyrights protect, broadly speaking, original works of authorship fixed in a tangible medium of expression. And that's taken right from the copyright statute. And as you can see, there are essentially three different types of requirements. There's originality. It must be a work of authorship, and it must be fixed in a tangible medium. And taking those in turn, for originality, there are essentially two elements. For something to be original in the copyright context, it must be independently created by the author, so not copied from someone else's work. And there must be a minimal degree of creativity involved, which is a low bar, but still not always satisfied. And maybe this requirement is best illustrated by two court cases as examples. In one of the cases, there was a phone book at issue that essentially consisted of subscriber names and numbers, and those elements were simply alphabetized in alphabetical order and printed. And so because the names and numbers are essentially just facts, what the copyright would have related to is sort of the presentation or the presentation of these facts. But the court held that merely putting something in alphabetical order, which is very customary, it does not meet the threshold of minimal degree of creativity. Yet in a different court case where there was essentially a White or Yellow Pages book involved that categorized the subscriber names and businesses in different categories, and sort of had some creativity in how the elements were arranged. There was a minimal degree of creativity, even though the copyright would only relate to how the facts are presented, not the facts themselves. So it's a low bar, but it is a requirement to satisfy for copyright protection. In terms of work of authorships, the 8 categories are enumerated in the statute and are really quite broad. I won't read them aloud, but they range from literary works to musical works, dramatic works, and so on. And literary works, even though you might just think of a novel here or a fictional novel, literary works would also cover other writings like computer source code, for example, and other categories. So it's really broad protection. The last requirement is that for copyright is to actually fix it in a tangible medium. And so fixed here refers to, for example, recording it. Would certainly be satisfied if you wrote down if you wrote down a letter, that would be enough for fixation to occur. And even a temporary copy, such as in computer memory, can be enough in certain circumstances. And thinking back to the distinction between technology and intellectual property rights, the copyright itself gives the owner certain rights to exclude. And so while the actual article is closely related, it is the copyright relates to the intellectual property right, not the actual copy of a book, for example, so not the physical item. Exclusive rights granted to copyright holders include the right to reproduce, to prepare derivative works, distribute copies, perform publicly or display publicly. And copyrights last were created by an individual author for the life of the author plus 70 years. And in case of an anonymous work or a work made for hire, it's 95 years from publication or 120 years from creation, whichever is shorter. And we'll see works made for hire relates to, for example, when an employee creates something on behalf of the organization as part of the employee's duties. I should also say copyright protection is automatic upon creation, and there's no need to register it, for the initial copyright to accrue, but there's certainly procedural benefits to doing so, to registering the copyright, and doing so also creates a record of ownership, which can be helpful in connection with enforcement. On the right-hand side, there's a depiction of potentially overlapping copyright rights. In the interest of time, I think I'll skip over that and move to trademarks, which is the next category that we'll talk about. So trademarks protect a company's brand by identifying the source of a product or service and distinguishing that source from the products and services of others. And as I briefly alluded to earlier, there are essentially two types, trademarks and trade dress. And all the marks shown on this slide here, I'm sure are familiar to everyone in the audience. But trade dress itself, just by the way an article looks, that can identify the origin of that product or service, as well as I'm sure is apparent from some of these pictures. Trademark rights accrue when a mark is used in connection with products or services, but registration has several benefits. And one of the benefits of trademark registration is that it puts others on notice and provides greater rights if it ever came to enforcement, for example, in terms of certain presumptions that would be available. And frankly, it's helpful in that, when a trademark is registered, there is a search performed of conflicting trademarks, and so by actually registering it, others presumably would find it if it is closely related, and that in itself might help prevent a dispute simply because the other organization might take up a different name instead of something that is closely related. The application process for a trademark is also with the United States Patent and Trademark Office, and with the trademark side of that agency. It consists of an application and an examination that looks for conflicts with other marks and some technicalities. And then a publication occurs, which permits others to raise objections if the third party thinks that the mark is too close. And registration then occurs upon proof of commercial use. In terms of the strength of a trademark, the U.S. Patent Office has some helpful guides, and there is a spectrum of the strength of protection, which ranges from fanciful or arbitrary marks all the way to generic marks, and I've shown that spectrum here on the bottom of the slide. Some of these are best illustrated by examples, and they are actually taken from what the USPTO provided on its website. But a fanciful mark would essentially be an invented word just for that product, and Exxon would be an example for petroleum. Pepsi might be an example for soft drinks. Arbitrary marks are actual words. They're not invented words, but they have no association with the product or service. And one example here would be Apple for computer products, but certainly not Apple for an actual Apple stand, because that would obviously relate directly to the product or service. But Apple for computers would be an example of an arbitrary mark. Suggestive marks suggest some quality of the goods or services at issue, and one example of that might be copper tone for suntan oil, since copper tone sort of suggests what the product is about, but it is different from just describing a quality of the product outright. That would be descriptive, and an example of that would be, say, creamy for yogurt might be considered a descriptive mark. And the generic mark itself is actually not protectable. That would just be the common name for the product, and so that is on the other end of the spectrum. And I'm not sure why the presentation goes back to the first slide, honestly. I'm hoping it stops doing that, or maybe I will just scroll to the slide here. I think we're back again. Okay. So then, looking at trademarks from a sort of from a maintenance perspective, it's important for trademark owners to what is called police the trademark, and that the term refers to making sure that internally the trademark is used consistently and that everyone complies with how it should be used. It also is important to monitor the marketplace for unauthorized uses. So essentially, the owner has an obligation to look for third parties that might infringe the trademark, and to to make those third parties stop. Since the mark protects sort of protects the identifier of your product or services, it's important to ensure that that in the consumer's mind that identification takes place. And with respect to trademark licensing, that's important to keep in mind as well. So, for example, if you had a reseller that resold some of your products, that reseller would be using your marks, under your permission. And in situations like that, it's important to make sure that there's some quality control in place so that your mark is actually associated with the high quality that your goods and services enjoy, and to make sure that there's no consumer confusion with respect to that. And that brings us to the last category of IP rights, which are trade secrets. And trade secrets are, broadly speaking, capable of protecting any type of information that is useful in competition, so long as that information remains secret. And so a trade secrets owner must take reasonable measures to keep the information secret. And that piece of information also has to have some competitive value. But there are a number of common types or categories of trade secrets, such as customer list, for example. You need to keep it secret, but would obviously have some commercial value. Software source code, inventions that haven't been filed, business plans, those are all types of trade secrets, or types of information that could qualify as trade secrets if those requirements were met. Trade secrets can last indefinitely, as long as they remain secret, but there is no protection against independent development by third parties. So if someone else comes up with the same recipe, with the same business plan, or with the same patent application that was never filed because you wanted to, or you decided to keep it a secret, there is no trade secret protection against that, which from a public policy perspective makes perfect sense. And if for some reason your trade secret becomes publicly disclosed and disseminated, that would void trade secret protection as well. So as a practical matter, sometimes, especially contrasting trade secrets with patents, if an aspect of your product is sort of readily discernible by just looking at it or handling it, trade secret protection would likely be difficult because there's no way of keeping that information secret. And the patent, would grant protection for a limited period of time. But if we're, concerned with, say, the inner workings of an algorithm that can't be seen by looking or using a product, trade secret protection could certainly be valuable. What's important to keep in mind as you're sort of going about your day-to-day business is that you need to protect this, especially when the trade secret is shared with third parties. Non-disclosure agreements or confidentiality clauses are very important in the context of employment or contractor agreements. In addition to those, you should limit the disclosure to what's really necessary for the business, because obviously the more widely it's disclosed, even if on a confidential basis, the higher the probability that there could be some disclosure, whether accidental or intentional. And so this brings us to the next slide. I hope this overview sort of provides some feel of what these different intellectual property rights are about. And often, as you go about your day-to-day business, there will be, if you have a new business idea or something that you're pursuing, there could be certainly, many of these different intellectual property rights that are relevant. And so the idea was here to sort of be able to spot what different protections are available and highlight some of the best practices. In the interest of time, I think if there are any immediate questions, Christine, we could certainly take some now, or otherwise we can dive into the second part, which deals with employees or consultants.
Yeah, I think let's keep going, and we can tuck them in at the end.
Perfect. That sounds great. So, with respect to employees and consultants, the IP rights that we've talked about in the first part, they typically vest in the person that created or developed them. And so, if an employee of an organization, say, developed a new idea for a patent, for example, it's important to make sure that the rights to that invention, if that IP is within the realm of what the employee did as part of the business, should be assigned to the organization so that the organization can use it in its business going forward. And it's best to address that by way of having an agreement with the employee that contractually spells out what the expectations are on both sides. There are some default rules that could apply too, but these default rules can vary between different types of IP, and copyright is one example of that. So for employees, there is this work-for-hire doctrine that we've briefly touched on earlier, and while that work-for-hire doctrine may vest certain IP rights in the employer, that doctrine does not apply beyond copyrights, for example, and there are also some requirements that need to be met for that go beyond this overview presentation. And so, as a best practice, even though the default rules could sometimes be helpful, it's best to spell everything out in detail so that there are no surprises. For independent contractors, the default rules, would be more biased towards the contractor as the person, sort of providing, a service to an organization. And so here, even more so, it's important to ensure that IP rights are addressed. And so let's look at potential contracts for employees, and often they're referred to as proprietary information and inventions agreements, or PIAs for short. And they essentially cover an employee's obligation with respect to proprietary and confidential information from the perspective of trade secret protection, for example, and also rights in work product or intellectual property rights that accrue. And so, it can be spelled out in such agreements, what IP rights should transfer to the employer, and to make sure that confidential information is protected. It's also helpful to address in such agreements that employees should, of course, not bring materials or third-party information from other sources to their employers. So say if an employee switched jobs, that employee should, of course, not bring materials from the prior employer into its new job, because into his or her new job, because those materials are proprietary to the previous employer, and it can be helpful to set that expectation forth in writing to make sure everyone's on the same page. These agreements, of course, should also comply with state laws, which sometimes circumscribe what types of inventions are assignable to the employer. So, for example, an invention that is conceived purely on the employee's own time without using the employer's resources, and that doesn't have anything to do with the employer's business, might be an example of an invention that should, ownership should remain with the employee. And certain states have laws regarding that, and it's helpful to remind the employees of those laws in the agreements too. And lastly, these agreements are also a good way of cataloging any prior inventions that an employee may have made. So, even if they're not bringing any materials, if they've previously been the inventor of a patent for a prior employer, it's helpful to not ask, of course, for any confidential information, but just to sort of catalog and to make sure that again, everyone's is on the same page. One concern there might be, for example, that prior invention, if incorporated into a product that the employee is working on, might be, the invention belongs to the prior employer. So it's good to keep things separate and to make sure that employees understand some of these considerations. With respect to consultants, the objectives are largely the same, but for consultants, it's good to also spell out in detail what the actual service is that the consultant provides. And there's an employment law overlay, which I'm not going to touch at all. That's an employment issue that goes beyond my expertise. It's of course important to correctly classify contributors as employees, whether full-time or part-time, vis-a-vis contractors. I'm not touching on this topic at all, but it's generally a best practice to spell out in a contract, whether it's in the contract itself or in a statement of work that's attached to the contract, what the expectations are for the service that is being performed. And often disputes arise, with respect to what was supposedly covered. So the more detail that is included, the more helpful it often is to make sure everyone's on the same page. There's often, just as time goes by, and if a project takes like 6 months, by the time it's completed, people's memory is fuzzy about what was actually required. And so it's good to spell that out in writing for both parties. With respect to the IP issues, well, they're similar to those in the employee context. A consultant might have, a different position towards that issue, because if the consultant, say, worked on similar types of services for different organizations, then he or she may be bringing into this engagement, certain IP that she developed previously, for example. And as a result, when it comes to an assignment of that IP, consultant may see a need to actually use that IP, be able to use that IP going forward. So it should only be essentially the embodiment that is transferred, but not the IP right itself. At the same time, a company that engages a consultant, may take the different position that it wants ownership of both the deliverables and the IP rights, because it paid for the consultant's time, and so there's no uniform answer that it's that could be applied to all contexts. It's sort of really important to distinguish between the deliverables on the one hand and the IP rights on the other, and then see what makes sense in the specific circumstance. But just thinking through this topic can be quite helpful in actually understanding the issues and then addressing it with a consultant as this agreement is negotiated. And I think that brings us to the last part, which is what happens when an organization actually partners with others. So it's here not just an employee or a contractor performing services. It's really sort of getting together and embarking on a joint development effort. And one way of thinking about the issues that arise in this context is to sort of have background intellectual property as a concept that captures everything that the parties bring to the table. before that joint development project starts. So if you have party A and party B, typically parties collaborate because they have sort of unique expertise in a specific area, and in coming together, each party applies its expertise. It's good to think critically and to sort of memorialize or catalog what that background IP is. And often, if such a collaboration happens, there's jointly developed IP that comes out of it. And absent an agreement to the contrary, if both parties are involved, often there will be joint ownership of such newly developed IP, which is one possible outcome, but it can have unintended consequences because different types of IP sort of have different requirements attached when they're jointly owned. Just to give you a concrete example, for a patent, each co-owner has an undivided interest in the entire patent. So, one party could exploit the patent and make money off of it without having to account to the other unless an agreement provides differently. For copyrights, on the other hand, there is a duty to account that courts have recognized. And for trademarks, joint ownership is highly disfavored because trademarks actually identify a single source of a product or service. And so if they're jointly owned, it's not quite clear. It kind of runs counter to the purpose of that intellectual property right to have it jointly owned. And there can be a risk of actually losing the mark if there actually arises confusion as to whether a certain trademark relates to party A's products or party B's products, if they're different. So for trademarks, joint ownership is not there's some tension between the actual IP right, and it could be a risky proposition. So what to do in this context? It's helpful to think through these issues ahead of time before the collaboration starts. And licensing IP rights can be a helpful solution to many of these issues. The parties ideally discuss up front how ownership should be allocated. One possibility that as a commercial matter gets close to sort of both parties being able to exploit the IP is that one party owns it, but licenses it to the other on a non-exclusive or an exclusive basis. And so, for example, if party A and party B, if they really come together with expertise in different areas, but each party, focuses on a different field, by way of a license, you can split up where that IP could be applied by putting field of use restrictions around it. And so as a commercial matter, you sort of you are able to share the IP rights as a commercial matter, but ownership itself may not be joint in the sense that one party owns it but licenses it to the other. And again, this is sort of intended to be a high-level summary or high-level overview to flag some of the issues that can come up so that they can be then thought through and properly addressed. Lastly, in terms of prosecution and enforcement, that's also something that's helpful to address in an agreement, simply because the default rules can be confusing. One party, it obviously takes money to, for example, file a patent and get it through the examination process at the U.S. Patent and Trademark Office. So it's the cost can be shared if an agreement so provides, or one party can be sort of leading the charge and funding the prosecution of the patent. Similarly, with enforcement, if a patent is infringed, party A and party B might have different interests in whether to actually enforce the patent against an accused infringer, and litigation obviously costs money as well. So providing for some of these considerations up front can just save a lot of time and hassle further down the road, because they provide clarity to the parties, provide clarity to the parties up front. And I think that brings us to the end of this presentation, and we have about 10 minutes left for any questions, which I'd be happy to address. And thank you so much for your time, and I really appreciate it.
Great. Thank you so much. Okay, so I am going to go through some of the questions that have already come in, and live listeners, feel free to send in more, and as we are able, we will get to those that we can. To start out, thinking back to the 4 different types of intellectual property, what is the expected timeline for those that need registered with the government for that process to take?
Sure, and so I think the spectrum ranges from patents on the end that takes the longest. I would say it can vary because as you file a patent with the U.S. Patent and Trademark Office, if the examiner raises many objections, the process can get dragged out. I think it's usually 1.5 years, at the quickest, to several years, and it can really vary depending on if you can imagine if you're in a crowded area where there is a lot of patents are filed, there's the inventions are fairly closely related to one another. There might be a larger number of rejections that the examiner issues, whereas if in an area that is not as crowded, could go quicker. With respect to, and I think that holds true for trademarks as well. I'm not as familiar with what the typical duration would be, but I would think maybe in the order of a year or so could be a right ballpark too. But I'm not completely sure about that. And then, of course, with respect to copyrights and trademarks, with respect to copyrights and trade secrets are never registered with the government at all. So there is no application process, although it is helpful as an internal matter to sort of catalog what an organization considers to be its trade secrets in case that ever came up. And with respect to copyrights, I'm not sure about the timeline for the registration process, but again, the copyright protection essentially commences once it's fixed. It essentially occurs, without registering it, but registration with the government can be helpful but the copyright protection essentially starts once you fixed it in a tangible medium.
When you were talking about trademarks, you gave some great examples of how names and logos can be protected under copyright law, under trademark law. They can be trademarked potentially according to that spectrum. But is it also possible, I already gave it away, for a logo or a name that is creative and fixed to be protected under copyright law in addition to trademark law?
So I think that's a tricky question because presumably that word or slogan would be very short. And so if we look at the works of authorship, if it's just a word or two, you could argue that it falls under a literary work. But I think there could be some protection there, but I think it's helpful to sort of differentiate between these two different rights. And again, trademark is concerned with identifying the source, and so I wouldn't say it's not possible at all to seek copyright protection as well. But I think there might be some challenges that arise in that context. It's difficult to sort of give an answer that covers all without going into too fine-grained specifics.
Absolutely. In situations where the business or nonprofit is very small and maybe a founder has created intellectual property, is there a way for them to license it in a way that they donate the rights to the organization. So they don't have to, the organization doesn't pay, but the creator just says, hey, we're giving you this.
Yes, I think, broadly speaking, an assignment doesn't necessarily have to be, there, for an assignment, which is sort of a contract, there has to be some consideration on the contract law, but it would certainly be possible to, to think about, sort of, the amount that has to be paid isn't fixed, and I believe that sort of an arrangement whereby it's donated could work as well. I'm not too sure of how the mechanics of this work. I haven't addressed that specific. I haven't encountered that specific instance, so I don't want to give an affirmative answer, but that's something that I think could be considered.
Thank you. We are thinking about copyright. As you've mentioned, as long as something meets the requirements that are here on the screen, no registration is required. However, if an organization would like to register copyrights themselves, or copyrights, is it something that they could do themselves, or is this something very complicated that requires the assistance of a lawyer?
So I think in general the Copyright Office actually provides very helpful resources on its website, and so I think those could be a very helpful starting point. That said, assistance by an attorney is of course always something that can help avoid issues from the get-go. But I think the Copyright Office is a good starting point, and then if those materials aren't cleared, and I would recommend seeking the help of an attorney.
We have had a couple questions. Yes, this recording will be sent and made available to all of you, so you can come back to this information, as will the slide. Is it possible for an organization to protect a slogan or a tagline that they associate with their goods or services?
Yes, that is possible, and that would fall under the rubric of trademarks as well. So in addition to the logos that I just showed by way of example on the slide, certainly if a slogan is associated with that product or service, that is something that would fall under the broad rubric of trademark protection.
Okay, so jumping a little bit further into the presentation where we were getting into some specifics of situations and kind of managing and handling IP rights. If there are two organizations that are already working together and maybe they have developed some intellectual property together and they didn't have a written agreement, is it too late for them to establish one now?
So I think that it's never too it's never too late to sort of get together and to sort of sort things out, what the parties consider their situation to be. It's of course a best practice to do it up front, but when doing it later, I think it's important to be upfront in any agreements that it's being done later, and that some of the default rules may have already sort of led to an application of it. So for example, if the default rules provided, just as an example, that a patent was jointly owned, then an ownership interest could have already arisen if the patent was filed. So in that case, essentially, ownership can be transferred as needed to to get to this new position that the parties would like to have under this project, and that would apply, from the time of that agreement going forward. But there might be some, for lack of a better word, cleanup that would need to also be considered as part of that, simply because some of the default rules may have already been triggered. But absolutely, it's never too late to. It's never too late to sort of